In this video, we'd like to talk about a land use case that recently went before a Kitsap County hearing examiner. It involved the issue of whether normal maintenance of a gravel road requires a permit. This seems like a simple question, but we think it exposes important issues about how county government works. The situation arose at the Kitsap Rifle and Revolver Club, and before beginning, we'd like to say that the club had been involved in a very long-running and well-publicized dispute with the county, a dispute that involves a number of different issues. And in this video, we're not trying to make a general comment on that dispute. The Kitsap Alliance of Property Owners is concerned with issues that might apply to any property in the county, issues that have to do with whether land use ordinances are reasonable and are enforced in a fair way. If you live in the county, these are issues that should concern you. The case arose when the Kitsap Rifle and Revolver Club began adding gravel to an existing road on their property, a road that intersected with a county road. This is a picture of part of the road, and as you can see, it could use a little work. The county said the club needed a permit for the work because in adding new gravel, they'd widened the road, and the county issued a stop work order. The club said it hadn't widened the road, that it was merely performing normal maintenance, and eventually the case went to a hearing examiner. A front-page story about the decision appeared in the Kitsap Sun on June 10th. The examiner ruled that the county had not shown that KRRC had widened the road. Since this was the supposed violation of code, KRRC won the case, right? Actually, no. The examiner said it didn't matter if KRRC had widened the road because merely adding gravel during maintenance constituted an alteration of the road that required a permit. Is this a logical ruling? If you read the comments about the ruling posted on the Sun blog, you'll see that the overwhelming majority of people say the decision is clearly wrong. Many feel the examiner was ignoring the logic of the code in order to side with the county. People who commented asked, for example, if anything you do during normal maintenance is an alteration, do you need a permit to fill a pothole in a road or to pull weeds? In fact, the ruling is so odd that even the county said it wouldn't enforce it in all cases. Both sides were unhappy with the decision, so the case went back to the hearing examiner. This time the examiner repeated his finding that it had not been shown that KRRC had widened the road. But he said KRRC needed a permit because the gravel had been temporarily delivered on the side of the road, in the shared KRRC and county right-of-way, and this constituted a change in the road. Does this make any sense? No. In considering this ruling, it's important to keep some things in mind. The gravel was dumped on the side of KRRC's road in such a way that it did not, at any time, obstruct traffic. The company doing the maintenance had a backhoe present and says the gravel was moved away from the county road within 10 minutes of being delivered. The owner of the gravel company testified that he had done this kind of delivery hundreds of times and had never been required to get a permit and had, in fact, never heard of anything like this. When a KRRC official asked the inspector if he would work to resolve the issue without a citation, he refused to do so. When KRRC asked if there had been a complaint about the use of the gravel, the county responded that there had not been a complaint, that this was a county-initiated citation. Is this just a trivial issue? No. The cost of the permit KRRC was told they needed was over $600. That's more than the cost of the gravel. So the club decided to contest the citation. But its cost for taking the case to the examiner, while not fully determined, will clearly be substantial. KRRC paid $500 to bring the case before the examiner. They also had to agree to pay an unspecified total for administrative fees billed at $125 an hour, and they have so far spent at least 60 hours preparing evidence and testifying. We think the case highlights important issues. For example, can the hearing examiner, who is hired by the county, really be considered as unbiased? Or, in dealing with the examiner, is a property owner guilty unless proven innocent? Indeed, in this case, KRRC was apparently guilty even after it was proven innocent, twice. Then there is the issue of selective enforcement. Many people who posted to the Sun blog clearly felt this alleged violation would not have been a problem if it had happened at another property. That's just not the way government should work because it suggests the county might apply land use codes selectively in order to pressure citizens on completely unrelated issues. Finally, one writer made the excellent point that if you need a permit to do even trivial things on your property, this is really just a new form of taxation because permits cost money. and these issues may become even more important soon. The county has proposed major changes in how land use codes are enforced. The proposal, known as Title V, moves code enforcement from the current system of civil law into one of administrative law, a situation in which county powers are greatly expanded. The proposal is still under review. It has not been adopted by the commissioners, so it's not possible to know exactly what its final form will be, or even if it will be adopted at all. But property owners find many features of the Title V draft to be frightening. For example, low-level DCD staff members may be empowered to write citations that can have harsh punishments, fines of up to $1,000 a day. Also, county staff members may be able to enter property without the owner's permission and without a warrant. And in the proposed system, a property owner who appeals a code enforcement citation must bring that appeal to a hearing examiner. And of course, that raises the question of bias and also the issue of cost. So in closing, we want to repeat that the issues we've been discussing are specific to land use regulation. We're not trying to comment on the general situation of the gun club. The things we've been talking about, illogical and biased interpretation of land use regulations, selective enforcement of the law, and ever-increasing fees for use of private property, are things that should concern all county citizens. These issues are central in the current discussion of Title V, a proposed new way of enforcing land use provisions. So if you're concerned about these issues, this would be a very good time to express that concern to your county officials.